Good morning, students. I'm Dr. Rakesh Kumar Gupta, and I will be teaching you a paper called Corporate Law. In today's session, we will be discussing the meaning of a company and its characteristics through a PPT. So let's start. So first of all, we'll discuss the definition of a company. The company's definition is given under Section 2, subsection 20 of the Companies Act 2013, which defines companies as, it means a company incorporated under this act or under any previous company's law. इसका मतलब है कि कोई भी कंपनी जो कंपनीज एक्ट 2013 में इनकॉर्पोरेट हुई है या इससे पहले के किसी एक्ट में, तो इससे पहले भी कंपनीज के बहुत सारे एक्ट थे, जैसे इंडियन कंपनीज एक्ट 1866, इंडियन कंपनीज एक्ट 1882, कंपनीज एक्ट 1913 एंड कंपनीज एक्ट 1956. तो कोई भी कंपनी चाहे वो 2013 में रजिस्टर्ड हुई है या 1956 में रजिस्टर्ड हुई है, दैट विल बी कॉल्ड कंपनी. बट दिस डेफिनेशन do not tell us exactly what company means is. So for that, we will be discussing the definition of Professor Henne. He said that a company is an incorporated association, which is an artificial person created by law, having separate entity with a perpetual succession and a common seal. So according to this definition gives so many features of company, like it is incorporated association, artificial person, perpetual succession, and common seal. So we will be discussing these features into the next slides. So first of all, we'll discuss the first feature, that is called incorporated association. So association, incorporated association. So both of the definition talked about the incorporated. So company come into existence only after incorporation. So before incorporation, company cannot come into existence. So as we know that to form a partnership, the registration of partnership is not compulsory under Partnership Act 1932. In the same sense, registration is not compulsory in case of a individual firm. But to create a company, it is very essential to register it under the Companies Act. So when we registered companies, so registrar of company, that is called ROC, issued a certificate, and after certificate of incorporation, company come into existence. So that is why it is called an incorporated association. The second feature is separate legal entity. This is a very important feature of a company. So company's existence or company's entity is entirely different from its members. So company has a separate legal existence. It is an artificial person which is created by law. So it can enter with the third party into a contract by its own name, or it can be sued by his own name. So what do you mean by that? So जब भी कंपनी फॉर्म होती है तो इसका एक लीगल एग्जिस्टेंस सेपरेट होता है इसके मेंबर से. तो ये अपने नाम से किसी थर्ड पार्टी के साथ कॉन्ट्रैक्ट कर सकती है. तो कोई थर्ड पार्टी कंपनी के ऊपर स्यू कर सकती है और कंपनी भी थर्ड पार्टी के ऊपर अपने खुद के नाम से स्यू कर सकती है. टू अंडरस्टैंड सेपरेट लीगल एंटिटी फीचर more clearly, now we are going to discuss some cases, some leading cases. There are two leading cases. The one was Sullivan versus Sullivan and Company Limited, 1897, and Lee versus Lee Air Farming Limited. So let's go through these cases in detail. So the case was very old, 1897, this case was held. So in this case, there was a person named Sullivan, who was the owner of a prosperous business of shoes. He was engaged in the manufacturing and sale of shoes. He formed a company and sold his entire business to a company called Sullivan and Company for rupees 40,000 pounds, which consists of Sullivan himself, his wife, his daughter, and his 4 sons. Total 7 shareholders. Because to form a public company, there is a minimum requirement of 7 members. The purchase consideration was paid by the company by allotment of 20,007 shares, and debentures of £10,000 and the balance in cash to Mr. Solomon. The debentures carried a floating charge on the asset of the company. 20,001 shares of the face value of £1 each were allotted to Solomon, and 1 share of £1 each was subscribed by the remaining 6 members of his family. Solomon and his 2 sons became the director of this company. Solomon was the managing director. The company went into liquidation within a year due to trade depression. At that time, the statement of affairs was like that. The total asset of the company was £6,000, and the liabilities of Solomon as a secured creditors and a debenture holder was £10,000, and unsecured creditors was £7,000. Thus, its assets were running short of its liability of rupees 11,000 by 11,000. The unsecured creditors of the company contended that the company, through incorporated under the Act, had never an independent existence. In fact, it was Solomon company alone, because all the members of his family and Solomon itself was the member of that company. But the House of Lords held that the existence of a company is quite independent and distinct from its members. Shareholder may also be the creditor of the company. The court recognized the separate and independent personality of the company. One argument put forth on the behalf of unsecured creditor was that the company was the agent of Mr. Solomon, and in truth, the business belonged to him and not to the company. The court opined that it is not the case. In fact, Mr. Solomon was the agent of the company and not vice versa. Solomon's case established beyond doubt that, in law, a registered company is an entity distinct from its member, even if the person holds all the share in the company, that is, a company has separate legal existence. There is no difference in principle between a company consisting of only 2 shareholders and a company consisting of 200 members. In each case, the company is a separate legal entity. So it was held in that case particularly that company has a separate legal existence from its members. So member and company are 2 different identities. One of the leading case was Lee versus Lee's Air Framing case, Farming Limited case. In this case, the principle established in Solomon case was also applied in the case of Lee versus Lee and Framing Company. Lee formed a company with a share capital of £3,000 for the purpose of carrying on his own business of AL top dressing. Lee subscribed to shares worth of £2,999. He was the beneficial owner of the shares and also the sole governing director of the company. He got himself appointed as the chief pilot of the company, and under statutory obligation caused the company to insure him against liability to pay compensation under the Workmen's Compensation Act. He was killed in a flying accident. His widow was granting compensation for the husband in course of employment. Court held that Lee was a separate person from the company he formed, and compensation was due to the widow. Thus, the rule of corporate personality enabled Lee to be the servant and master at the same time. Thus, a company and its member are 2 distinct parties. That is, a company has separate legal existence. So, after going through these 2 famous cases, we come into conclusion that company has separate legal entity from its members. So, these are 2 separate entities. So, the next feature is perpetual succession. So all the firms like partnership is basically influenced with the death, admission, retirement of a partner, and an old partnership firm dissolved and a new partnership firm was formed and has been created. But in case of company, it does not dissolve with a change of its member. Member will come, member will go, but the company will go forever. Being an artificial person, it is created by law and it comes into and only by a legal process of winding up. It come into existence as well as wind up with a legal process. So whether all the member of the company will change or in fact dies, company's existence will not influenced by the existence of members. In a leading case, The life of company does not depend on the death, insolvency, retirement of any or all shareholder and directors. In the case of Meat Suppliers Guildford Limited, during the war, all the members of a company were killed by a bomb while attending a general meeting, but the company continued with its legal representative of dead members. So even an atom bomb cannot influence the existence of a company. That is why it is called a perpetual existence. The next feature is common seal. So company must have a common seal. Company being an artificial person, it deals with the outsiders. So any contract which is authorized must bear the signature of the person who is signing the document. So company being an artificial person cannot personally sign all the documents like natural persons. So that is why every company owns common seal, which worked as its official signature. Any document not bearing the common seal will not be binding the company. The next feature is limited liability. Generally, all the companies have limited liability unless and otherwise specified in memorandum of association. The liability of shareholder is different from the member liability of the company. Shareholders generally have limited liability. The liability of member of a company is limited to the extent of unpaid amount remaining on their shares. For example, if a shareholder owns 100 shares of rupees 10 each and he had already paid 7 rupees per share, so he had already paid 100 multiplied by 7, that is 700 rupees. So his maximum liability will be 3 per share, that is 100 into 3, in this case 300 rupees. So company cannot ask more than 300 rupees from the shareholder, even in case of winding up of the company. Next feature was transferability of shares. So the shares of a public company are freely transferable, while there are restrictions in case of private company on the transferability of shares. So private company cannot easily transfer its shares, but a public company can easily transfer its shares. And the next feature is separate property. Company, as we discussed already, that company is a legal person and is capable of owning, enjoying, and disposing of property in its own name. The property of company is not the property of its shareholders. In the leading case of Macura versus Northern Assurance Company Limited, it was held, member cannot have any insurable interest in the property of the company. In this case, Macura insured the property of company by its own name, and when he claimed from the company, then the insurance company denied to settle the claim of Macura because the property belongs to the company and he took the policy by his own names. So that is why his claim was not settled by the company, because the member is different from the company and company has its own property, which is the property of a company and not the property of its members. So now we can go through the features once again. So the first feature was incorporated association. So we can sum up by this slide. Incorporated association means it is compulsory for a company to get itself registered. If it is not registered, a company cannot be formed. Then separate legal entity. Company has a separate legal existence distinct from its members. It can be sued and be sued. It has its own assets and liabilities. Perpetual existence. A company have a perpetual existence. Member will come, member will go, but the company goes forever. So the existence of a member cannot affect the company's existence. Then it's common seal. It is the official signature of the company. Company being an artificial person cannot sign document personally. So that is why it has a common seal which work as the official signature of the company. Then limited liability. Generally, the liability of a company has limited to the extent of unpaid amount of their shares. So basically, we're talking about the liability of members of the company. So the liability of the member, as discussed earlier in the example. Next is transferability of shares. Shares are always transferable through some time with some restrictions. As we discussed that in case of public company, shares are freely transferable, but in case of private company can restrict the transferability of shares. Then separate property, as we discussed in the case of McKenna versus assurance company, national assurance company. So the property of the company and its shareholder are not joint. So company owns the property by its own name. Thank you.